Hello students and welcome to week 2. This week we're going to delve even a little further into confidentiality regulations and exceptions. What is confidentiality and when, if ever, would you break it? This is a very common interview question for human services agencies. Have your spiel ready to go. Practice it now. What is confidentiality, and when, if ever, would you break it? Officially, the definition of confidentiality is: confidentiality entails the ethical and legal responsibility of mental health professionals to safeguard clients from unauthorized disclosures of information given in the therapeutic relationship. The ethics of confidentiality rests on the premise that the clients in counseling are involved in a deeply personal relationship and have a right to expect that what they discuss will be kept private. It is necessary to encourage the clients to develop the trust needed for full disclosure. No genuine therapy can occur unless the client trusts that what they say is confidential. The legislature or the law has decided that a greater public good results from protecting client communication than from making client disclosures fully discoverable in a legal proceeding. But there are exceptions, and we'll get to that later. Confidentiality is both an ethical principle and a legal right. Counselors must abide by the Code of Federal Regulations, 42 CFR, and HIPAA governing client confidentiality, being aware that a violation of confidentiality can result in a fine, criminal prosecution, loss of licensure, certificate, and/or other disciplinary actions. On the slide are a couple scenarios of what you would do to protect confidentiality. Name some other things that you need to do to protect confidentiality. Client files and case materials shall be handled, discussed, and stored in ways that maintain confidentiality, including locking of the file cabinets that house client information and shredding of the documents. Any piece of paper that has a client name or a client number on it. Do not discuss cases unless there is a need to know. So it's not appropriate, even with your coworkers, to be gossiping about your clients. Does that person or does that team have a need to know? Shred your documents. Don't discuss information in the hallway. Protect your notes and documentation. For example, be sure that computer screens are not in view of the clients. Put away all materials on your desk and in your office at night and when the clients come into your office for a session. What about emails? Being careful to not communicate any confidential materials in an email is important. Now, there are times when you can break confidentiality, and the 4 big exceptions, so this would be part of your spiel, is harm to self, like suicide, harm to others, homicide, child abuse reporting, elder abuse, and dependent adult abuse reporting. So the four: harm to self, harm to others, child abuse, and elder abuse. It is very important that you inform the client of these exceptions to confidentiality in the very first session that you meet with them, even before they start talking. Informed consent document, which is coming up in our lecture for next week, describes the exceptions and much more information about treatment that is needed in an informed consent document. The client signs the informed consent document and also receives a copy of the document for their review and records. If you're working in a team, all team members need to agree on what is a need to know. So, for example, you're working on a team, criminal justice team, drug court team, something like that, and drug use, criminal activity, and general progress are things that everybody needs to know, including the judge and probation, etc. Maybe the team doesn't really need to know about more personal items of childhood traumas and that kind of thing. But if you put the team and the program at risk if you don't share all of the information that you have agreed upon. The best practice, of course, is to have the client themselves report to court, report to probation, CWS, report to their employer, report to their program participants. In early treatment, the most important thing is for the client to learn honesty. It's even more important to learn to tell the truth than to stay clean. We can work on that a little bit later. Always inform a program supervisor as soon as possible anytime you go outside to report an incident. When it does become necessary to break confidentiality, it is a good practice to inform the client of the intention to take this action and to also invite the client to participate in the process. Privacy is the freedom of individuals to choose for themselves the time and the circumstances under which and the extent to which their beliefs, behaviors, and opinions are to be shared with or withheld from others. We do not disclose confidential, personal, identifiable information obtained during the course of professional work in our writing, lectures, or other public media unless that patient, client, or subject has consented in writing. Just about everyone who has ever received medical care has heard of the Health Insurance Portability and Accountability Act, HIPAA, of 1996, the law that regulates the use and disclosure of protected health information, PHI, held by covered entities such as health plans. But far fewer are familiar with the special privacy protections afforded to alcohol and drug abuse patients' records by 42 Code of Federal Regulations, CFR, Part 2. 42 CFR regulations were promulgated in 1975 and last changed in 1987. Now, more recently, they were just changed last year, and we're going to go into that in a minute. The Code of Federal Regulations apply to federally funded programs. Federally funded programs include those that are a unit of government and get certain tax benefits, those who are a 501c3 and get tax benefits by being a nonprofit, those funded by Medicare or Medi-Cal, and those programs funded by SAMHSA through the state government. Let's say like a grant. Those programs have to hold themselves out to provide alcohol or drug abuse diagnosis, treatment, referral for treatment, and prevention. This would include narcotic treatment programs and detoxification programs, any program, counseling program, or clinic that holds themselves out through their advertising, through their name, and other ways to determine that the primary business has to be substance use disorder diagnosis and treatment. And then if those two conditions are there, they're federally funded and they're a drug and alcohol program, then you have the highest level of confidentiality. And if you don't adhere to that high level of confidentiality, you can risk all of your funding as well as other consequences. Patients are current or former patients, including those who are deceased, are protected by 42 CFR. So remember last time we said that records may need to be held for 10 years. So even a former patient up to 10 years ago, their identity and their personal information is protected. In the slide, it says that we cannot identify patients as a drug abuser or a drug user, either directly or indirectly. So let me give you an example of an indirect identification. So let's say I'm working in a hospital kind of clinic, but I hold myself out to be a drug and alcohol specialist, meaning I'm covered by 42 CFR because the hospital will bill for Medi-Cal. Then I say to my colleague, this person is a patient who takes Suboxone. Now, Suboxone is only used for opiate use disorder, alcohol use disorder. So even though I didn't say that they were an opiate user or have an alcohol use disorder, I did inadvertently or indirectly disclose that information. Under 42 CFR, which is different than other confidentiality regulations, the person becomes a patient upon self-referral or request for services. So, for example, in 42 CFR, if the person calls up and says, yes, I'd like to come to walk-in and my name is Jane Doe, that is the moment that they become a patient, a client. And the name Jane Doe then becomes confidential. Even if they never show up for treatment, they became a patient upon self-referral or request for services. However, under 42 CFR, if a client doesn't show up for a drug and alcohol appointment that was arranged by a third party, we can share that information. So let's say the probation officer calls up and says, I want Jane Doe to be seen by you guys. And we've never heard from Jane Doe, and we want, the probation says, yes, I want Jane Doe to be seen. We say, okay, we have walk-ins on Tuesdays. And then the probation officer calls up on Wednesday and says, hey, did Jane Doe show up yesterday? And if Jane Doe did not show up for an appointment arranged by that probation officer, then we can say, no, they didn't show up. So we can share information if the client has never been a client at any of a drug and alcohol program. Otherwise, we have to have a consent or a written release of information, even for billing, Medi-Cal, or insurance, or other payments and collections. And again, that is different than other types of programs confidentiality. Patient identifying information, meaning all of this stuff is confidential. That includes the name, address, telephone, client numbers of the patients that we have seen, medical or treatment information about a specific person, memories or impressions of staff. So even though the information never made it into the client's record, but the staff remembers that person, they cannot go around and talk about that information without the client's permission. A visual image of the person, let's say in the media. So that's why you don't see a lot of advertising, if you will, about programs with the testimony of the clients standing there saying, oh, this is the greatest program ever. It takes special permissions. We can't just do that because the client wants to do that. In a waiting room, sometimes we have general waiting rooms, and sometimes we have drug and alcohol specific waiting rooms. And in a general waiting room, we cannot identify, okay, everybody here for your drug group, come on in. We can't do that. So the patient, because then of course when everybody stands up, everybody goes, oh wow, look, they're in a drug program. So again, sometimes we have specific waiting rooms and sometimes we have general waiting rooms. It depends upon the clinic. Now, really, I talked about the big four exceptions to confidentiality when you can break confidentiality, but there's actually 10 different ones. Just cover the four when you're talking with clients. These other 6 then will be talked about in the informed consent document. But you might want to remember this slide in particular. And there's also a handout under Files in the menu to describe the full exception list to confidentiality under 42 CFR. So sometimes in your interview, you'll nail that legal and ethical definition and you'll get the big four, but then your interviewer may say, are there any other exceptions to confidentiality? And so knowing these other ones might be important too. So with very limited exceptions, almost everything requires a patient's consent for disclosure of protected health information, even for the purposes of treatment payments. We talked about that, or healthcare operations. The consent for disclosure must be in writing. That consent is also known as a release of information or an ROI. So one of the exceptions is internal communications. So you have a drug and alcohol program and certain people are employed within that program. So it is okay to talk with the clerical person, for example, about giving the client's name and information and so forth, because the clerical person works within the drug treatment program. And that is fine. That clerical person doesn't need to know because they're putting together your files. So, for example. Another internal communications is some drug programs have internal drug testers. And again, the drug testers need to know the client's name and number and so forth and so on. We communicate the results back and forth and so forth. So internal communications without a written consent are approved and okay. Now, if you do not provide any patient identifying information, that is okay to break confidentiality, but of course you didn't provide any patient identifying information. And I'll give you an example of that in a few minutes. You can also disclose to medical personnel in medical emergency. This medical emergency exception has to be an eminent medical emergency, not something that might happen this weekend. Okay, so an example of this is your client tells you, wow, I have a party this weekend and I have a bunch of pills, opiate pills that I might take this weekend. That you may be thinking, oh my God, this client's going to overdose, but that's this weekend. It's not imminent. There's nothing that you can do to break exception of confidentiality under those circumstances. Now we'll talk about other ways around confidentiality, but technically the medical emergency needs to be happening right there. So the client comes into the clinic and begins to have difficulty breathing in the lobby. Can we call the medical personnel and the ambulance? Yes. The client's there at the clinic having a medical emergency, and the fire or the ambulance arrives first, and they're going to help this person, and that is an exception to confidentiality. And in that case, we can say to the medical personnel, this person does have an opiate use disorder. They may be having difficulty breathing. Can you administer Narcan, for example, and save the person's life? So, of course, we would do that. Another exception to confidentiality under 42 CFR is a court order. So not just a subpoena. Just getting a subpoena, that's great. We don't hide away from subpoenas. But a subpoena is not enough to get drug and alcohol programs to release information. It takes a court order, meaning the judge has to look over the case. The case has to be the crime actually has to be so severe, and the court cannot get any information from any other person, then they may in fact order, the judge literally orders the therapist to testify. Okay. Another exception is crime at the program or against program personnel. So if a theft happened at the program, could we call the police and say, hey, we think Jane Doe stole computers from the program? Yes, we can do that. We could say, hey, it's Jane Doe and they live at 123 First Street. Yes, we can give that address. That's an exception to confidentiality. If the crime happens on the premises of the program, so regarding two clients get into a fight against each other, but they're at the program, can we call the police? Yes, we can. The crime is happening at the program, whether or not it involves program personnel, and we can give law enforcement the client's information. If a therapist or a counselor is being threatened, and they're getting threatening texts even at their home or on their cell phone, but it's because of a patient and it is a program personnel, that too then can be reported. So there are ways to protect the programs and protect the client information. in a way that, again, we would share as least as possible. That's the primary principle, but we can still break confidentiality. Research audits and evaluations are all allowed without an exception or written consent. So a researcher comes in and says, hey, we need to look over all of the records for people that are in this small co-occurring program because you got funding or whatever, and we're a 42 CFR program. Yes, we would have that researcher come in and look at the records, and that would be okay. The child abuse, elder abuse, we talked about that. Just a note, it is the initial report only that is allowed. So, for example, you call up Child Welfare Services and you say, hey, I got this child abuse report I need to file, and it's on a 10-year-old client. My client who's the parent just said that they hit their 10-year-old. That's a child abuse report. I need to file that. And 3 weeks later, the social worker calls up and says, hey, how's that case going about that child abuse report that you filed? Well, that's no longer an exception because it's 3 weeks later, and they're not talking about the initial report. They're talking about progress that has happened since then. However, if the social worker calls up the next day and says, hey, I can't read your report, something happened in the fax machine or whatever, yes, then you can answer the questions. Same thing with elder abuse. You're making the initial report. You're trying to share. It's a balancing act between the information required, and we're going to talk about that in a minute, but also the minimum necessary for the purpose of the disclosure. So we wouldn't go on and on and on about this elder abuse situation, and they're an alcoholic and they can't take care of themselves, and they also use, marijuana too on a day, etc. We're not going to go on and on. A qualified service organization or a business associate agreement. These are things that exist in contracts. So all of the contractual partners of the county's drug and alcohol programs. So when we contract with a sober living environment or we contract with a recovery residence, those organizations, we are covered and can share client identifying information with those organizations, and that is allowed, even without the client's written consent. Now let's give you some examples. This important slide, so I know I'm taking a while on this slide, but let's say a client comes into your program, your drug and alcohol program, and you get federal funding. Client comes into your program under the influence and insists upon driving away. Can you report that to law enforcement? It's not really a medical emergency happening right now because the person might cause an accident. We can't really use that one. Well, it could be crime at the program, but they're already at the public street level. So no, we can't use that one. What we can use is number 3. So the patient, no patient identifying information. So if I run out of the program and I look and I see that patient driving away, and I see that just like any other citizen could see, I see that the person is driving north on Jensen Avenue and they're in a red pickup truck with a license number XYZ. Can I call law enforcement and tell them that? Yes. That's anonymous patient identifying information. I didn't say, hey, I'm from drug and alcohol and I'm calling about one of my clients that just drove away. I'm not saying that. I'm calling up to law enforcement and saying, hey, I believe that there is a person driving under the influence there in a red pickup truck, license XYZ, driving north on Johnson Avenue. So do you see the difference there? If you don't provide any patient identifying information, you can, in fact, report crimes or different situations without identifying them as a drug or alcohol user. Now let's say we covered the client comes into the clinic and they have a seizure. What can you do? Yes, you can call law enforcement. That one is under the exception of the medical emergency to and you're going to disclose information to a medical personnel. Okay. So remember again, it's minimal necessary information to be disclosed. What we're going to do though is pull out that client's record. Let's say the one that had a seizure in the lobby, right? We're going to pull out the client's record and we're going to document the exception and what happened. So for example, in the progress note, I would say, client came in, they were observed to be having difficulty breathing, having a seizure potentially in the waiting room. The ambulance was called. This is under medical exception. And here's what was told to the medical personnel. Here's what was requested. And we document all of that into the client's record, as well as an incident report, separate incident report to your supervisor. So again, anytime you have to file an exception to confidentiality, and you have to file a child abuse report or an elder abuse report, anything like that, you're going to inform your program supervisor. Okay, so this slide has a lot of information on it. These are the reasons. So you're going to have to think about, what can I break confidentiality? If it fits into one of these 10, then the answer is yes. Now, disclosures of alcohol and drug information. So the patient does consent. That is required for nearly every other disclosure. Okay. Now, again, remember, except for within the program, we can talk about patient identifying information, and between a program and the entity that has control over that program. Okay, so if of course I work at Drug and Alcohol Services, I'm under the control of the Behavioral Health Department, the Behavioral Health Director, and I can share client information if I have or she has a need to know about information that I can share. Drug and alcohol programs may not share information with other client providers who are outside the treatment program without patient consent. So let's say I'm working at, drug and alcohol, and I am a case manager and I take the client to a routine medical appointment. Okay, so if there's not a medical emergency, etc., etc. And I forgot to have the client sign a release of information for their physician. And the physician, I'm sitting in the waiting room, the physician comes out and says, hey, I'd like to talk to you about Jane Doe that you brought in. Can you tell me, what their drugs of choice are? Uh-oh, I forgot to have a consent signed. So the answer is no. There's, again, remember that previous slide, there's not a medical emergency. I forgot to have the written consent, etc. Of course, if the client is still with you, you would say, just a minute, let me talk to Jane Doe first, and then you whip out your consent and have them sign it. Remember, consent cannot be verbal, it has to be in writing. So carry those forms around with you, and we'll get to that in a little bit. So these release of information forms, there's also a required format for the form. And that's why verbally you may not cover all of those requirements. There's something like 13 different requirements for the form. Now, even though the form allows disclosure, we're going to just include the minimum amount necessary, state the purpose for the information sharing, and there has to be a revocable or an expiration date or an event needed on the form. So, for example, this form expires after my child custody hearing is over. That's fine to do. We don't know how long that's going to last, etc. Revocable consents then can also have an expiration date. And right now we've gone as long as 2 years. So the releases don't expire for 2 years. So in situations like that, we can have a release long after a person leaves our program, and that release is still valid. So we can respond to requests for information. Now, the criminal justice consents, a lot of those are non-revocable because the client, in lieu of being prosecuted or convicted or in lieu of jail time, they have chosen to go into treatment. And because the two things are connected, the client cannot not revoke their information. So we're tied together with the court in those. We be sure that the client knows that. A revocable, a patient consent and signature is always needed on a release of information. The client's signature is required. The therapist's signature is not required. Okay, so this is a client that is signing the consents. The consents, as I mentioned, need to be in writing. So let's say your client's in jail and you go visit your client in jail, and the client says, "Hey, Star, I want you to talk to my probation officer and see what you can do about getting me out of here," or whatever, right? And you go, "Oh, darn, I forgot to bring that form." And your client says, "Oh, that's okay. I'm just going to write you a note. Let me write you a note, a permission slip here, and sign it, and then you can talk to probation." Is that allowed? No, no, because the client's note might not have the required format. Remember all those 13 elements. And so it's a useless note. You're not going to be able to use that. So again, as a person who works in a substance use disorder program under 42 CFR, you need to carry around those release forms. Otherwise, you're going to go, "Wow, no client, I'm sorry you're in jail, but I can't talk to him because, of course, I forgot the release of information." Now, I could say, "I'm going to fax it over to you, I'll bring it tomorrow," or whatever like that, but no, you cannot call the probation officer without that consent, unless there was a previous one already in the client's file, which is still good, and that could happen. Now, integrated care is a program that provides both treatment of co-occurring disorders. So COD, co-occurring disorders, is a mental health diagnosis and at least one substance use disorder diagnosis. So by definition, the co-occurring program provides substance use treatment, right? So all co-occurring programs should adhere to 42 CFR. Okay, so by definition, they are a 42 CFR program. So the SUD treatment staff have to have the higher level of confidentiality. Many people think that mental health confidentiality is more stringent. That's not true. It is the substance use. The information is called super sensitive information. And even though you have an integrated chart, client record, you have different firewalls and different viewpoints that you can see. So let's say a client has a substance abuse, a co-occurring episode of treatment, and they also have a mental health episode of treatment, either together at the same time or separately. The issue is that the mental health person providing those services cannot see the substance use disorder program information unless they're in the same co-occurring program. The substance use counselor, however, can see the mental health information because they're the ones that have the higher confidentiality. Okay, so generally we're going to get permission from every single client, and in your forms I'm going to put records, release of information, sample forms in the files menu so that you can see what these forms actually look like. Remember I said that drug and alcohol treatment programs may share information within their own identified substance use disorder program, but we're not permitted to share with others outside of that. There is, again, I talked about team communications, so you're working on a criminal justice team, etc. You still need to have written permission to share with other staff that are on that multidisciplinary team, so with the probation officer, with the social worker, etc. Even though a lot of other agencies can just communicate with a multidisciplinary team, under 42 CFR, the stronger confidentiality, we can't do that. And as I mentioned again, sometimes these other barriers don't exist. In kind of a one-stop shopping agency, they can share information amongst each other. But even if we're combined with the social services or human services, the drug and alcohol and the co-occurring program are still separate from the overall health agency. So sometimes people say, well, why, if that's the most restrictive, why don't, if the mental health and the drug and alcohol people need to talk to each other, why don't we just treat all of the records under the most restrictive and call the whole thing a 42 CFR agency? No, we really don't want to do that, because then not only do the drug and alcohol staff need to get all these consents and monitor them and all this stuff, now everybody has to do that. And the mental health people, that would be overkill. They don't really need to do that. We could do it on a case by case rather than treating all records under the most restrictive law. So we lose flexibility to share some of the information that we can for other clients. So is it important to get your permissions from the clients even before starting treatment? Yes, on the very first day when they come in, at the front desk even, get those permissions. Remember, once we have the written permission, then the barriers to communication disappear. Okay, again, remember, under California law, it's elder abuse and child abuse. There's court orders, there's tears off, the duty to warn, harm to others, etc. Sometimes people have heard about domestic violence and they think that that's an exception, or gunshot wounds or other suspicious, like I say, domestic violence injuries. No, the substance use disorder program do not need to disclose those information. Again, unless it's a dependent adult or an elder or child abuse. And we'll go over that in a few minutes. If it's just so to speak, domestic violence between two adults, that cannot be disclosed or reported, even to law enforcement. Okay, so warnings out of substance use disorder programs should be anonymous. So for example, drug and alcohol services, just by virtue of the name, so I say, hey, I work at drug and alcohol services, right? I've already disclosed everything that I talk about has to do something with drugs and alcohol, right? So we try to not use that, even in filing a child abuse report. We don't want to disclose too much information. So I'm not going to say, hey, I need to file this child abuse report and I'm from Drug and Alcohol Services. I might say I'm from the Behavioral Health Department. Okay, so again, trying to make the information a little bit more anonymous, even though it's a required disclosure. Okay. SUG treatment programs, again, you can call 911, we can have a police emergency, but again, we're going to not go on and on about this person's history, etc. We are just going to talk about the crime that happened on the program premises. Other differences in confidentiality. So another big one under 42 CFR is that there's no re-disclosure of information, even with the consent or release of information. So remember that, let's say I'm working on the drug court team and the client signed the consent to work with the drug court team, right? And they understand the limits of confidentiality and that we work as a team. Well, that probation officer that's on that team cannot take the information that they got from being on that team and then go tell other officers information that they got in the team meeting. That's called a re-disclosure, and that would not be allowed. Okay, so you'll notice a lot when we have the drug court team that there are dedicated officers or there are dedicated social workers involved in family treatment court. And so what that means is that information within the team needs to stay within the team. Now we also have to have a statement about this prohibition of redisclosure. We have to have a special statement on all of our emails, our reports, our fax cover sheets, etc., so that those reports that we provide don't get distributed to other staff who are not on the team. Okay, so what we have to have, for example, are email lists that are very specific to a team. Okay, so we have, for example, a very specific Prop 36 email, and just those people that are on that list are members of that team. So there's a lot of email management and so forth, so that just the people who need to know get to know information. Okay. Okay, so previously I told you that 42 CFR has been around a long time, hasn't really been changed, except for recently it did get some changes, some updates in 2018. So the definition section was changed to be more modernized. So for example, we no longer talk about substance abuse and dependence. The newer phrase is substance use disorder, SUD. And so the definitions have been changed in that section. Also, we no longer use the phrase detoxification. Instead, the new phrase is withdrawal management. And so 42 CFR has now been modernized with those new languages. Okay, so what else has changed? What else has changed is that we need to now provide or offer a copy of the summary of 42 CFR to the clients. If they choose to request, I need to request a copy of 42 CFR, you could do that. And that's at our front desk. And so it needs to be available to clients so that they understand the scope of 42 CFR. Now, remember previously we talked about clients become a client when the client self-refers or requests services for themselves. Remember that? That's when they become a client. Now, it's been changed a little bit. So now a person can also become a client if they were referred by another healthcare professional, then they become a client at that point. So, for example, a physician at a hospital or a social worker who is working discharge at the local hospital calls up and says, hey, drug program, I have Jane Doe, and she's going to come over tomorrow. She's getting out of the hospital, and we need to set an appointment for her. Can you do that for us? Yes, we can. And at that exact moment, Jane Doe became a client. So again, this doesn't open up the whole thing in terms of confidentiality. It's only healthcare providers when they call us to make an appointment. Then Jane Doe's name and information that is given to us by that hospital or medical provider does become confidential. Okay. Let's see what else has changed on here. So, what makes it more difficult is previously we used to have a section that says, you know, sign a consent, and it says to whom all of my probation officers, you know, it just says you can communicate with the probation department. Well, now we have to have specific names of the people as well as the organization for non-treatment healthcare entities. So it's no longer okay just to have a consent that says, yeah, you could talk to the probation department. No, now we need to have the names of the officers that are on the different teams, and those probation officer names need to be on our consent. It starts to get very, very complicated. So some of the recent changes have been great to 42 CFR. I think it allows a lot more communication between healthcare providers, which of course under HIPAA is needed. But when we're talking to other people, it makes it more difficult because now we have to have names and we're constantly changing our consents. Consents don't really expire, as you know, but they can expire. And so imagine in a drug treatment program, all of these different consents. Literally, when a person walks in the door, I think right off the bat we have them sign 6, 7 different consents. Each consent has to be, and we're going to talk more about this next week, each consent is very specific. And again, they don't expire until they expire. And so we have all of this management of consents that we have to do, which is very different than other counseling or mental health programs. Okay, so now we're going to delve in a little bit into the different exceptions. I'm sorry this lecture is going long, and it is going to. There's a little bit of required reading this week as well. But the first exception I want to talk about is mandated child abuse reporting. So you do have to file a child abuse report. It does not need to be a pattern of abuse, and you are not the investigator. So you have to report if you have a suspicion of child abuse, or it was described to you and you believe it to be child abuse. Then you need to make that report. Any and every incident needs to be reported to you separately. So let's say you're working with a child, let's say age 15, they're coming in for drug treatment and they say, last week my parents slapped me across the face. That's child abuse report. There you go, file that report. The next week they come in and they say, you know what, now my mother, was yelling at me and was emotionally abusive, called me stupid and didn't give me dinner and I haven't eaten in 2 days and so forth. Then that might be emotional abuse or neglect. So every single incident that gets reported to you has to be reported as a separate child abuse report. Telling the child's parents, your supervisor or employer, or the school counselor or the principal of your concerns do not fulfill any mandate to report directly to the Department of Social Services. So even though you told, let's say you work on a school campus and you told the principal of your concerns, which you probably will do, that and your principal says, okay, I'll take care of the child abuse report, don't count on it. No. You are the person who heard and took the report. You're the person that has the suspicion, so you're the person that needs to make the report. In the confidentiality folder under the law and ethics in the files menu, there is the attached list of phone numbers for the reporting of child abuse report. Those phone lines are open 24/7, and so remember your mandated child abuse report. This is called CANRA, the Child Abuse and Neglect Reporting Act. It was passed in 1980. The primary intent is to protect children. The Child Abuse Reporting Act is found in the California Penal Code, sections 11164 to 11174.3. Legally mandated reporter is defined as those who are involved with children on a regular basis, including child care providers, preschool teachers, clergy members, educators, instructional aides, for example, law enforcement, medical professionals, that includes substance abuse counselors, mental health professionals, commercial film and photographic print processors, etc. And again, the primary intent around this law is to protect children. The child abuse and neglect, what do you have to report? You have to report anything that sounds like physical abuse, sexual abuse, including both sexual assault and sexual exploitation, willful cruelty or unjustified punishment, unlawful corporal punishments or injury, and neglect. A child is defined as someone who is under the age of 18, and the perpetrator is any person including a child. So if an older child is abusing their younger brother, hitting them all the time, that kind of thing, that's a report under the Child Abuse Reporting Act. So again, the perpetrator is any person, can include a child, but the victim is a child, and then the information gets reported. So who do you report to and when? It is a reasonable suspicion of child abuse. Your report needs to be made immediately or as soon as practically possible by phone. Again, those phone numbers are in the Files menu. The telephone report is made to the County Department of Social Services, and those phone lines are available 24/7. A written report then, after you make the phone report first, then a written report has to be forwarded within 36 hours of receiving the information. So you have to do both. It's a two-part report. And there is a form, DOJ Form 8572, to make that written report. On that child abuse report, they're going to ask you for your name, business address, telephone number, what makes you a mandated reporter, information and source for the reasonable suspicion. You do need to provide the child's information if you know that, and the alleged abuser's information if you know that. So again, you may be working with the child and know more about the child, not so much about the abuser, but that's okay. You would say, hey, my 15-year-old client told me about this friend of the family, Uncle Joe. I don't really know anything else besides Uncle Joe. I don't know where he lives, but he lives in the same town, and any other relevant information. So you just share what you do know. And even if you don't have all of the specifics, that's okay. You have to file the report. If you call the child welfare worker and they refuse to take the report, then you have not met your mandated reporter obligation. So it used to be that they could describe the situation and say, no, that's not child abuse report. If you feel that it's child abuse report, then you need to insist that the child abuse report needs to be taken. Now, nothing could be founded, and that's a separate issue, but you did your mandated reporter requirement, which is you made the report. If there's multiple joint information, okay, so let's say you're working on a school campus and the child shared this with you and the teacher and the school counselor, so all three of you knew about this child abuse incident, you can file just one report. That's fine, but you have to ensure that that one report gets submitted and reported both by phone and in writing. So it's almost like you may as well do your own to cover yourself. But if you're working as a group, you can file just one report. The identity of you, the reporting party, is confidential. So even though on the child abuse report they ask you for your name and your address and your phone number, that's okay. The reporting agency is not supposed to share that with the family or the child. Where'd this report come from? You are actually protected and you have immunity from any criminal or civil liability because you reported as you were supposed to do. Afterwards, you as the reporting party will get a disposition on the suspected child abuse report. So you'll get information about what happened with your report. Okay, so that is exception number 1, all about child abuse reporting. On to exception number 2, which is the mandated elder and dependent adult abuse reporting. So the definition of an elder is any person residing in the state of California who is 65 years of age or older. A dependent adult is any person residing in the state of California who is between the ages of 18 to 64, who has a physical or mental limitations that restrict their ability to carry out normal activities. A dependent adult is also a person aged 18 to 64 who is an inpatient to a 24-hour health facility. So let's say you just had surgery, you're age 50, you just had surgery and you're in a skilled nursing facility because you had this surgery. You are considered a dependent adult at that point because you reside in a 24-hour health facility. So this mandated reporting requirement only applies to persons living in California. So you find out that your aunt back in Arizona had been abused. Is that a mandated elder reporting? No, your aunt lives in Arizona. So you don't have an obligation to report. Remember, these reporting requirements specifically state that it's information that you found out in the course of your job. As well, you can also report personal information that you have, let's say about your neighbor, etc. And that's a good thing to do. But in general, we're talking about your performance at work in a drug treatment facility. Now, adult abuse reporting is under a different set of regulations. They're under Welfare and Institutions Code sections 15630 and 15658A1. Go ahead and take a look at these elder abuse and neglect definitions. Includes physical harm, pain, mental suffering, deprivation by a caregiver. Neglect is negligent failure to exercise self-care or care that a reasonable person would take. Physical abuse, sexual abuse, financial abuse, abduction, neglect, isolation, and abandonment. So as you look through some of those definitions, you could see that an older adult, these definitions might be especially pertinent to older adults who suffer from substance use disorders. The reasonable suspicion here, it has to be observed by you. You have to have knowledge of an incident that reasonably appears to be abuse or neglect, or is told by the elder or the dependent adult that she or he has experienced behavior constituting abuse or neglect, or you reasonably suspect that abuse or neglect has occurred, then you shall file the report. Self-care includes, but not limited to, assisting in personal hygiene or the provision of food, clothing, or shelter, providing medical care, that's physical or mental, protection from health and safety hazards, prevention of malnutrition and dehydration. Self-neglect can be as a result of mental limitations, substance abuse, poor health, incompetence, illiteracy, or ignorance. And so if any of these situations occur, you need to make that report to Adult Protective Services, which is also at the Department of Social Services, immediately via phone, and then a written report to follow within 2 working days. And that is Form SOC 341. So, exception number 3, suicidal clients. There is a required reading on suicide and homicide. The handouts are under duty to warn and protect. and there's also a no self-harm contract in that packet of information. What we're looking at here is Evidence Code 1024, and the provider may break confidentiality if a client represents sufficient harm to themselves or at risk of harming another person or another person's property. Any disclosure should contain the minimum necessary amount of information to accomplish the purpose of the communication. There is no duty to actually prevent the suicide, but absent reasonable efforts to do so, a mental health provider is exposed to civil liability. So you need to have a duty to protect suicidal clients. Kind of the crux of the issue is knowing when to take the hints seriously enough to report the condition. Counselors must take the cry for help seriously and have the necessary knowledge and skills to intervene once they make the assessment that the client is suicidal. You're going to look at the required reading on this topic, and the information on both homicidal and suicidal clients in that reading will be on the quiz. So what are reasonable steps to protect a suicidal person? There's a wide variety of steps that you can take. So a client says to you, yes, I'm thinking about it. Maybe, and again, this is from lowest intervention at the top to the highest intervention at the bottom. So, and this is not all of the steps that you could take. You can have others that you may have thought about or have even used in the past. So there's self-care plan where the client is responsible. You think the hints are kind of just thoughts, no real plans, etc. So you're going to say, will you take care of that? Can you call your wife to help you? You know, those kinds of things. A disposal of the means. So if the client says, yes, I'm going to drink myself to death and take some pills, and then you say, can I have those pills? Can we have your neighbor come over and empty out your liquor cabinet and store it over at his house? That kind of thing, disposal of the means. So that's a reasonable step to take. Increased frequency of contact. So you client appear to be self-harming. Let's go ahead and meet every day and see how you're doing. And so you set a session every day at 8 in the morning and maybe even a phone call in the afternoon. Again, you can have a lot of different options in here. You may make medical or psychiatric referrals. So let's get you on some medication, some antidepressants. Let's make that appointment right here. Are you willing to do that? That kind of thing. You can give out the suicide prevention hotline phone numbers. Maybe you have some cards or a brochure. You be sure that the client agrees to make that call 24/7, that kind of thing. Consultation with other clinicians. So maybe you're unclear and you decide to talk with your supervisor about the situation and talk over the case and agree on a plan of action. So again, that protects you and it protects the suicidal person. You can request welfare checks by the police. You can seek legal counsel to be sure you're on the right track. There are facilities that do a 23 hours of a suicide watch. Here in San Luis Obispo County, that's called the Crisis Stabilization Unit. It's over behind Johnson Avenue on the health campus, and it's a 4-bed facility that they will be with you, and it's staffed 24/7, and the person can stay there and kind of calm down and maybe start some medicine and get some interventions right there, and you can, and the client can stay there, and then if they happen to get worse, then they can go into voluntary hospitalization or involuntary hospitalization. If they get better, then they'll get sent home, and again, maybe some of the other steps will take place. Whatever you decide to do regarding your suicidal client, you need to remember to document both the actions that you have taken in detail, including names of people that you consulted or reported to, dates, times, the agency that they work for, and document the rationale for those steps. Okay, so let's say you talked to the client's wife and she agreed to give the neighbor the alcohol, and the wife brought in the pills, and so you took them away. You would be writing all of that down in the progress note. What time? What's the wife's name? When did these things happen? Did you verify? All of that kind of stuff. Okay. Exception number 4 is the homicidal client. So the homicidal client, this is called duty to warn and protect. It's also known as the Tarasoff law, so you may hear it referred that way. Failure to warn an intended victim is professionally irresponsible. You need to warn the intended victim, notify the police within 24 hours, hospitalize the patient, or anything else that is reasonable under the circumstances to prevent the harm. So your client, this exception refers to your client. They are dangerous. They are homicidal. They're making threats, terrorist threats against other people. And your client has the means. They make the threat. There's identifiable victims, and the situation is imminent. Then you must do something about that. And confidentiality goes out the window. You don't need to worry about that. Go ahead and take whatever steps you need to take. Now again, there's a variety of steps that you could take. You could dispose of the means. You could have a no violence plan. You can call the police. You actually need to call the police within 24 hours. You could do that with the client there. Maybe the client will help remove guns from a house, for example, that kind of thing. So you need to protect the victims. You also need to notify the intended victim. Now, maybe you don't know. Maybe the client said it was the ex-girlfriend, but you never wrote down, you don't know who the client's ex-girlfriend is for sure. Again, you just need to give the information to the police, tell them that you're reporting under Tarasoff law, and they will help figure that out for you. They may come over, they'll ask you to perhaps detain your client, that kind of thing. There's a variety of things that can happen in here. You just have to do something, and again, you're going to document. Ewing versus Goldstein was a subsequent case to the Tarasoff law, and this expanded the duty a little bit to protect family members of the patient or credible third-party people who may be injured. So again, kind of thinking this case came out of the ex-wife was threatened, but the child or the children may also be in harm's way, even though your client did not expressly express opinions about hurting the children, it's possible that they're going to get hurt as well. So you need to duty warn and protect those victims as well. Current drug use and past crimes. So your client comes in, you know that they're currently using drugs, and is that a crime to be reported? No. Crimes, current and past crimes, current drug use is not a reason to break confidentiality. That's why they're coming to you. They need to be able to say, I used drugs today even. And again, your job is to counsel them and get them through this. Your job is not to be a police officer and get them arrested. Now, of course, there's exceptions to that. So if your client says, you know what, I murdered a drug dealer last week, and the drug dealer was an adult, you might have a lot of moral feelings about that and so forth. You may work with the client to self-report, but really that's not a reason to break confidentiality. So unless the past crime or drug use is elder abuse or child abuse, which it could be, then you can't use those exceptions. Unless there's a harm to self or others, but a past murder is not threat of harm currently, unless they say, well, I got to go back and take care of this other witness. Then, of course, you would have a duty to report, warn, and protect. So, unless there's a court order for you to disclose a past crime or drug use. So, sometimes this happens where a client gets another DUI, so to speak, and someone was killed or injured. You may get called to testify in that case, and the court reviews the case, and sure enough, it's a serious crime. Someone died, and so you may in fact then get ordered by the judge to disclose about what the client said about that previous DUI. Unless the client signs a release of information, that's possible too. Sometimes clients are remorseful and full of guilt about their past crimes, so you can maybe get them to sign a release and tell them that you'll help them through the process, but they're now in recovery and they really do want to make amends and self-report themselves to law enforcement, so that can happen as well. The issue here is it's complicated. There's no black or white answer. It really depends upon the situation. Privileged communication. The more to come on this next week when we address legal requirements under 42 CFR. However, this privilege belongs to the client, and it is designed for the client's protection, not the protection of the professional. If a client waives their privilege, which is, again, it's their right to do so, therefore then the professional has no legal grounds for withholding the information. Professionals are obligated to disclose information when the client requests it, but only the information that is specifically requested, and only to the individuals or agencies that are specified by the client. So next week we're going to talk about subpoenas and court orders and testifying in court and so forth and so on. But what I want to leave you with is that it is complicated, some of these issues. I'm glad that you're getting a chance to study law and ethics in a little bit further depth than I believe we've been able to present, and so I'm excited about that. Your agency that you work with, of course, will have a supervisor and will also have access to attorneys and so forth. So if you should ever feel nervous or scared, ask your supervisor about what to do, and um, and protect yourself. Document, document, document. You would even document that you talked to your supervisor and what your supervisor said. And that is perfectly appropriate. That goes right into that client's record. Okay? Now, your next steps for week 2 is to go ahead and take a look at the discussion forum. There's a question there worth 10 points to write your response and respond to 2 other students at least. There's extra reading materials under the menu, file menu, and under law and ethics, there's confidentiality. You need to read those materials. Really, it's just a few pages. Read those materials prior to the quiz, and then take your quiz for week 2, which is worth 15 points. Okay, good luck.